Hello everyone, my name is Habiba Bakari and this is Amira's Haven. In this video, I'll be talking about subsidiary legislations as a source of law in Ghana. Orders, rules and regulations made by persons or authorities by the power vested in an Act of Parliament or the Constitution are referred to as subsidiary legislations. Parliament has the primary role in making laws to regulate the activities of persons, bodies, authorities in the country as a whole. More often than not, it is unable to anticipate the challenges faced by such persons, bodies, or authorities in the day-to-day running of their activities. Through subsidiary legislations, such bodies, persons, or authorities are given the power by an Act of Parliament or the Constitution to make detailed laws governing their activities. Through subsidiary legislations, such entities are able to make new laws to govern new circumstances that would not have been envisaged by their parent act or the Constitution. Subsidiary legislations usually come in the form of statutory instruments, constitutional instruments, and legislative instruments. Statutory instruments, according to Article 295 of the Constitution, are instruments that are made directly or indirectly by a power vested in an Act of Parliament, a decree, or a law. That same article defines constitutional instruments as an instrument made by a power conferred by the Constitution. Section 1 of the Interpretation Act defines legislative instruments as an instrument that has a legislative character. It also defines an executive instrument as an instrument with an executive or administrative character, or a statutory instrument which is neither judicial or legislative in character. From the definition of statutory instrument above, it can be said that legislative instruments and executive instruments are both statutory instruments. Despite this, executive instruments are not considered to be subsidiary legislations within our jurisdiction. In the case of Bafo Osei Akoto versus Attorney General, the Local Government Act 1993 gives the President power to create a new district through an executive instrument. The plaintiff contended that an executive instrument is a subsidiary legislation. Therefore, it must be laid before Parliament and published in the Gazette the same day and comes into force at the expiration of 21 sitting days as stipulated by Article 11 Clause 7 of the 1992 Constitution. The court disagreed with the view of the plaintiff and stated that the purpose of laying a subsidiary legislation before Parliament for 21 sitting days was for it to mature into a binding enactment. Such procedures were alien to an executive order or an executive instrument. Also, executive instruments do not have a legislative character. Therefore, they cannot be considered to be a subsidiary legislation properly so called. Again, the court was of the opinion that if executive instruments were subject to the procedure outlined in Article 11 Clause 7 of the Constitution, it will cripple the executive, especially in times of emergencies, where they are required to act swiftly to protect the interests of its citizens and the country as a whole. In essence, executive instruments are not subsidiary legislations. Article 11 Clause 7 of the 1992 Constitution states that any orders, rules and regulations must be laid before Parliament and published in the Government Gazette the same day and comes into force at the expiration of 21 sitting days, unless that instrument is annulled by 2/3 members of Parliament before the expiration of the 21 sitting days. Or the 100 of Parliament standing orders also states that any instrument laid before Parliament must be referred to the Subsidiary Legislation Committee for its report and deliberation. The Subsidiary Legislation Committee must ensure that in its report it states whether or not an instrument is inconsistent with the Constitution or its parent act, whether or not it has a retrospective effect, whether or not it seeks to oust the jurisdiction of the court, whether or not it contains any matters that ought to be properly discussed in an Act of Parliament, whether or not the instrument needs further clarification, among others. A case where this procedure outlined in Article 11, Clause 7 was challenged was the case of Stephen E. Borte Okan versus the Electoral Commission and the Attorney General. In 2010, the electoral areas for Lesokuku and Kuro constituencies were 12 each, making a total of 24 electoral areas. The Local Government Instrument 2020 was laid before Parliament in accordance with the procedure outlined in Article 11, Clause 7. However, just before the expiration of the 21 sitting days of Parliament, the Subsidiary Legislation Committee added 4 more electoral areas to that of Lesokuku constituency, increasing its electoral areas from 12 to 16. The plaintiff brought an action to the Supreme Court for a declaration that action by Parliament was inconsistent with the Constitution. He also contended that Parliament did not have the power to amend a subsidiary legislation and that it only has the power to annul or approve a subsidiary legislation. The court upheld the plaintiff's claim and held that the powers of Parliament with regards to subsidiary legislations were limited to its ability to approve or annul them and did not extend to amendments of subsidiary legislation. Therefore, the 4 more electoral areas that were added to Lesokuku constituencies were of no effect. In essence, the electoral areas for Lesokuku constituency remains 12. All laws in Ghana are subject to the supremacy of the Constitution, and subsidiary legislations are no exceptions. In the case of Mensima versus Attorney General, the plaintiff was a member of a registered cooperative union which had the object of distilling a local gin called Apetition. The plaintiff broke free from the union and registered a company where he continued to do so. However, the members and officers of the cooperative union harassed him and impounded his goods. They acted in this manner in reliance on Regulation 3(1) and 37 of the Manufacture and Sale of Spirits Instrument 1962. The plaintiff brought an action to the court. Cooperative union and its officers were inconsistent with the Constitution. The court upheld the plaintiff's claim and stated that the action of the union and its officers infringed on the freedom of association of an individual as enshrined in Article 21, Clause 11E of the 1992 Constitution, as it sought to force an individual to join an association he or she does not clearly want to join. The court struck down that section of the law and held it to be null and void and of no effect. In conclusion, subsidiary legislations are laws made by persons or authorities by the power vested in them by an act of Parliament or the Constitution. Subsidiary legislations usually come in the form of statutory instruments, constitutional instruments, or legislative instruments. Though executive instruments are statutory instruments, they are not subsidiary legislations within the intendment of our laws and the interpretations given by the court. Any subsidiary legislation that is made in a manner contrary to Article 11, Clause 7 of the 1992 Constitution will be held to be void and of no effect. Also, any subsidiary legislation that is in conflict with the Constitution in part or in whole will be held to be null and void and of no effect. I hope you learned something today. If you found value in this video, please like, comment, share and subscribe. Until next time, have a lovely day.